Good morning. Are you Lamone Yman Jr.?
Good enough.
All right, folks, buckle in. We're diving into another tense probation revocation hearing. Meet Lamone Yman Jr., a man standing before the court once again, and this time, things aren't looking good. But before you judge, let's unpack how probation really works and why even small violations can spiral fast.
And will your client waive the formal reading of the motion in each case?
He will, Your Honor.
Okay. Mr. Yeoman, in cause number 19-32846, I have a first amended motion to revoke your unadjudicated probation. This shows that you were placed on probation November 12th of 2019 for the offense of aggravated assault with a deadly weapon, and that was a 10-year deferred probation. Is that correct?
Mm-hmm.
And then in cause number 23, DCCR 155.
Deferred probation means he avoided a conviction if he followed the rules. It's like a legal timeout. Behave, and your record stays clean. But break the terms, that conviction comes roaring back.
6, I have a first amended motion to revoke your community supervision. Shows that you were placed on probation July 17th of 2024 for the state jail felony offense of burglary of a building, and that was a 2-year term in state jail prison that was probated for 5 years. Is that correct?
Mm-hmm.
Each of these cases allege that you violated your probation. Count 1 in each case alleges that you failed to avoid persons or places of disreputable or harmful character, and specifically avoid association with any person previously convicted of a crime, or be present at a location where a criminal act is committed, in that you were supplying other residents of the Cheyenne Center with K2 synthetic marijuana. And is that true or not true?
True.
Whoa, K2? That's synthetic marijuana, known for unpredictable, sometimes dangerous effects. Supplying it inside a rehab-style center, that's a massive red flag. It's like breaking the rules inside the one place designed to help you.
Okay. Count 2 in each case alleges that you failed to report to the probation office as directed April 2nd and April 3rd of 2025. And is that true or not true?
True.
Count 3 in both cases allege that you possessed a drug, K2, on or about March 30th of 2025 in violation of your order. Is that true or not true?
True.
Not true? Okay. Count 4 alleges that you failed to successfully complete the SAFE program as directed. Is that true or not true?
True.
Count 5 in each case alleges that you committed the new offense of possession of a controlled substance, penalty group 1, August 8th of 2025. And is that true or not true?
True.
Count 6 in each case alleges that you committed the offense of possession of a firearm by a felon, August 8th of 2025. And is that true or not true?
Not true.
Count 7 in each case alleges that you failed to report to the probation department April 11th, April 21st, April 30th, and May 9th, June 6th, and July 7th of 2025. And is that true or not true?
Not true.
All right. Did you enter your pleas of true to counts 1, 2, 4, and 5 freely and voluntarily?
No.
And did you plead true to those counts because they're actually true?
Just no.
In each of your cases, I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Just no.
Do you fully understand them?
Just no.
And do you understand I think y'all did the paperwork backwards.
We did originally, then we corrected it. At least I thought we did.
So
There's a cap of 8 on 19-32846, and a cap of 2-year state jail on 53 DCCR 1556.
well, it's set. Hold on. Anna, can you send me back 23-1556. I just sent it.
That may be the third degree paperwork. I think he may be right.
Yeah. Okay. I think, so 23-1556 is the burglary of a building,
Obviously,
but y'all did TDC paperwork. And the other one, yeah. So those have to be right. So
we can read them.
I'm going to delete both of those.
That's fine, Judge.
I'll just hold this. We'll continue the hearing. I'm not going to go back over everything. We'll just go over the paperwork as soon as it comes through. And did y'all do it twice? You
We
said?
did, there was,
I got the numbers wrong. We did it.
Okay.
I have to redo them both.
Sorry.
That's my fault.
All right. I'm going to delete both of those. All right. Y'all just go have a seat in the jury box and we'll get that done. Okay. We're back.
If you're wondering why the paperwork chaos matters, it's because every number, every form, determines how long Lamone could actually serve. Think of this as courtroom housekeeping, but with life-altering consequences. And yes, even judges have to redo paperwork sometimes.
Back on with Mr. Yeoman, and Mr. Yeoman, in each of your cases, I have here on the computer documents that the state's marked as exhibit number 1. And again, did you go over these with Mr. Rojas? And do you fully understand them? And do you understand that if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And so it looks like the agreement is for a cap of 8 years in the burglary of in the aggravated assault case, which is 19-32846. And then, up to 2 years, which is the max on that state jail felony, and for whatever I do, for those to run concurrently or together at the same time. Is that your understanding? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Yeoman is not competent?
No, Your Honor.
All right, then I'm going to find that you entered your pleas of true in each case to counts 1, 2, 4, and 5 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probations, but I'm not going to do that today. I'm going to reset your case for a sentencing hearing, and then I'll get an updated pre-sentence report done. Mr. Nichols, does the state intend to put on any evidence with regard to the firearm possession or the other allegations, or just sentencing?
I will have probation speak to some of the not true entries, but the new case has nothing been filed yet, so
Okay.
I won't be presenting anything from it.
Okay. All right, then, anything that you think is important for me to know, get that information to Mr. Rojas, and he will present it to me on your behalf when we come back. All right, you can go back with the bailiff.
Mr. Yeoman has asked me to request the court for a PSI bond, even if you include an ankle monitor.
No, you're on a straight probation in the second case. You were on probation for aggravated assault with a deadly weapon. Apparently you violated and got another state jail felony burglary of a building, and I gave you an opportunity to remain on probation on the first case. I gave you a probation on the second case, and now you have admitted to supplying residents with K2 at the Cheyenne Center and committing the offensive possession of a controlled substance. I'm not going to set any bond. I don't think that is appropriate in either of these cases. You can go back with the bailiff.
And there it is, no bond, meaning Lamone stays behind bars until sentencing. This moment captures the harsh truth about second chances in the justice system. They're given, but rarely given twice. What do you think? Was the judge fair here, or should rehabilitation have trumped punishment?